I now welcome in person and via video conference representatives from the Department of Industry, Science, Energy and Resources. I understand information on parliamentary privilege has been provided to you. I understand and remind senators that the Senate's resolved that an officer of a department of the Commonwealth or state shall not be asked to give opinions on matter of policy and should be given a reasonable opportunity to refer questions asked to a superior officer or to a minister. This, of course, prohibits only questions asking for opinions on matters of policy and does not preclude questions asking for explanations of policies or factual questions about how they were adopted. I'm happy when you are able and settled in for the department officials to move through, and please state your full names and the capacities in which you appear today.
Bruce Wilson, the head of the Industry Growth Division in the Department of Industry, Science, Energy and Resources.
Peter Cully, head of the Small and Family Business Division in the same department.
And are your online witnesses? Are you?
Good afternoon, Senator. It's Caitlin here from Principal Advisor Markets Conduct Division in the Treasury.
Thank you. Thank you. Can I just check that Hansard heard that, because it dropped out for me?
No, we didn't hear it here.
Okay. Could you do that again, please? Thank you.
Sure. Toby Robinson, Manager of the Consumer Policy Unit in Treasury.
I think you might have been a little too far away from the microphone initially, so just take account of that. Would the department like to make an opening statement?
Yes, thanks, Senator. Chair. Thank you for affording the department the opportunity to appear before the committee. This statement is a follow-on from our previous statement and appearance before the committee. We understand Australia has one of the world's most competitive automotive sectors, both in the supply and sale of vehicles. And this provides Australian consumers with the ability to buy cars from over 450 models under 68 brands. It generates around $62 billion a year in revenue, with a net profitability last year of around $1.5 billion. The strength of our market compares to the US, which offers around 37 brands and reported an overall negative profitability in 2019. However, like all new car markets around the world, the Australian market is undergoing an unprecedented transition, which is applying pressure to the traditional car sales models. In particular, consumers are choosing smaller, cheaper, more fuel-efficient cars. Consumers are spending less time in showrooms and are not as loyal to brands. And new vehicle sales have fallen continuously for 30 months and profit margins are low. Manufacturing and retail business models globally are responding to these changing commercial pressures, with a growing trend to online sales and network restructuring. We are also seeing a continued trend towards business consolidation in the retail sector, with large dealership consortia buying up the smaller, less profitable operators. The Australian Government recognises the importance of a strong and competitive automotive sector, both in the supply, sales and servicing of vehicles. It also recognised that, as highlighted by the ACCC in 2017, there has been a historical power imbalance between manufacturers and dealers. For this reason, the government is putting in place a comprehensive suite of changes to the frameworks governing the automotive retail component of the car sector. These changes are intentionally designed to make the system fairer and more transparent for consumers, dealers and manufacturers. The first of these are the automotive franchising reforms that commenced on 1 June 2020 that amend the Franchising Code of Conduct in 3 key areas: improving end-of-term notification periods, improving transparency for capital expenditure requirements, and clarifying options for dispute resolution. It is the first time that a sector-specific part of the regulations has been included in the Franchising Code. The second of the changes relate to the franchising code coming out of the government response to the Fairness in Franchising report, which was released on 20 August 2020. These changes include doubling the maximum financial penalties and introducing voluntary binding arbitration. As a result of these changes and the heightened attention on the sector after the Holden withdrawal and dealer dispute, the ACCC announced on 22 October a change to collective bargaining requirements to allow franchisees to collectively negotiate with their franchisors without having to first seek ACCC approval. By joining together, smaller dealers may have a better opportunity to input into the negotiations than if they stay on their own. And thirdly, on 6th November 2020, the Legislative and Government's Forum of the Consumer Affairs agreed changes to strengthen protections against unfair contract terms in the Australian consumer law, including making UCTs unlawful and giving courts and tribunals the power to impose civil penalties, changing the definition of a small business contract by increasing the threshold to less than 100 employees and either using this or a business annual turnover of 10 million or less, removing contract value threshold, which will apply the protections to more contracts, and providing more flexible remedies to a court when it declares contract term unfair. I note the Treasury officials are here online to answer specific questions around the changes to the unfair contract terms. There is also other important work which will provide further benefit to the sector. For example, work is underway on improving supplier indemnification and consumer guarantee provisions in the Australian consumer law. This includes undertaking a regulatory impact assessment on a proposal to prohibit manufacturers from failing to indemnify suppliers. Also putting legislation in place to implement the mandatory motor vehicle service and repair information sharing system, which will provide a level playing field in the sector and allow consumers to have their vehicles safely repaired by the repairer of their choice, especially benefiting those in remote and regional areas. These recent and proposed changes announced by the government collectively provide considerable new negotiating leverage and a better safety net for dealers, but they have yet to fully take effect and will require time to measure their take-up and effectiveness. In addition to these regulatory reforms, the Minister and Department have been working within the three peak bodies in the industry to develop best practice principles for dealership agreements. These were requested by the AADA to improve transparency and guide the development of future automotive dealer agreements. In bringing the three peak bodies together, the Minister was clear that this should be an industry-driven exercise to develop guidance in line with existing obligations, rather than create or extend new obligations. This has been a challenging process, and we continue to encourage all parties to work together productively to achieve a common goal of selling cars to Australians. At this point, the three groups are not in agreement, as you have heard through the various testimonies, and the Minister is considering whether further engagement can resolve the current differences. In terms of how the principles could be applied, we take the view that an industry-driven and owned approach based on shared expectations is more effective in generating best practice than standards imposed through regulation. The latter can have unintended consequences or drive compliance-level behaviour. At a time where business models are responding to changing commercial pressures and where circumstances between brands and dealers can vary considerably, this is likely to be better than a uniform set of standards. Finally, the Department acknowledges that some automotive retail franchisees have raised concerns over a number of current compensation and new agreement practices. The Department notes that the recent and proposed changes have to fully take effect or be well understood and properly tested. We would encourage any party who believes that they are subject to unfair treatment or terms not to feel obligated to accept those terms and to seek legal advice. Where concerns persist, they should contact the ACCC. I'm happy to take any questions. Thank you.
Thank you very much. I'm going to commence with just a couple of questions. Can I ask, please, why responsibility for this continues to sit within the Department of, within the part of the department that's responsible for industry as opposed to small business? Was that historically because of car manufacturing taking place on a larger basis here, which informed the historical model for dealerships, which is now attention absent from the market, or is there some other basis for it?
Thank you, Senator. I guess the easy one, well, the first answer is as a portfolio, of course, where we operate across the portfolio. So we have the small business as well as the automotive industry areas inside the portfolio. So that's why the department is leading on it at the officials level. The ministerial responsibility are historical assignments that successive Prime Ministers have chosen to maintain.
So it hasn't been reconsidered in terms of, where the government needs to regulate the relationship of large overseas foreign-owned companies with Australian business entities. Do they normally sit within industry, within the department?
So consumer law sits with the Treasury. The department has responsibility for automotive industry issues as well as the small business and franchise code matters in this aspect, but it does straddle several departments.
Okay, so tell me why it still sits within industry.
Why is it within an industry? For two reasons. One, the changes that we were principally dealing with, which were to the franchise code, involved both the franchise code, the small business area, as well as the automotive retail sector.
Okay. So can I just ask very quickly, do you deal with the franchise code broadly in the Department of Industry, or is that done elsewhere?
Sorry, Senator, I missed the question.
You're dealing with all franchise code questions within the Department of Industry, or is that done by the small business part of the department?
Senator, the small and family business division, my division, has the overall responsibility for the entire franchise code.
Thank you. I think it must be a historical oversight based on, notwithstanding the fact there are many motor trades and industries. It does seem that it was off the back of the industry parts of having a local manufacturing market. Can I ask you briefly to give an overview of the advocacy you've received from both car importers and dealers?
Again, sorry, Senator, I do have a slight hearing impediment. I just missed that last part of the question.
No, that's no problem. An overview, please, of the advocacy received by government and the department from automotive vehicle importers and manufacturers and dealers.
Certainly. So we've had engagement with the various different parts of the sector through the process of developing the amendments to the franchise code, and that involved formal RIS or regulation impact statement consultations, as well as ongoing informal and formal discussions with all three groups. We've also had some consultations with a number of the individual car companies when issues relating to those companies came up, but I would note that the companies themselves haven't been particularly engaged with us on the overall policy framework. That comes through their largely comes through their the associations.
That's the FCAI.
Yes, the FCA have been engaged.
So the sorry, Senator Pratt, have you finished your questions?
Clarifying question as to whether the FCAI at all said that their members would withdraw from the Australian market if a mandatory code was introduced.
That's not That's not a point that's been made to me in that way. The point that has been made to us consistently through the consultations is that if regulatory frameworks are out of balance and too intrusive, it does risk the withdrawal of manufacturers. But I was not specifically given that particular piece of feedback.
Thank you. Over to you.
Thank you very much, Chair. I've deliberately asked today if Honda, Mitsubishi, Toyota, Mercedes-Benz, if any of them would withdraw from the Australian market if they were, if the principles that you've been developing were to become mandatory, and I can confirm they all said no. And I also asked them if arbitration became mandatory, would they leave the Australian market, and they all said no. Yet that was the strong evidence of the FCAI. And I guess I'm just concerned if the FCAI are the peak body for all the overseas manufacturers of cars, that perhaps they're not communicating as fully and as transparently with the department as one would hope, given the scale of the sector.
Well, that's obviously something you have to follow up with FCIA. I do note that there are, we have 68 brands in Australia. Some of those will be definitely operating at the margin, very small, narrow customer bases. So they would be the ones most at risk, I would imagine. I would imagine the majors, you would have to be imposing quite severe regulatory sort of restrictions before it would be the straw that broke the camel's back in terms of whether they operated here.
Exactly. And with regard to those mandatory principles being endorsed by the government, or the principles being endorsed and then being made mandatory by the government, every single representative of the dealers has indicated that that would be their desire, and in fact they encouraged stronger use of the word must instead of should for the principles. I'm sure you heard that evidence on Thursday.
So if I could just clarify a point in that Senator. These are not government principles. The Minister brought the three peak bodies together to develop, based on a request from the AADA, to develop a principles-based industry standard for compensation for OEMs looking to withdraw from Australia, rationalise their networks or change their distribution models. That was in a submission they made in our process. So the Minister brought them together and very explicitly asked them to go and develop an industry-led. The Minister asked the Department to facilitate that. So what has been developed as a set of words that was moving, we thought, towards an agreed position that would be industry's principles. They're not specifically ours or the department's or the government's.
So thank you for putting that so clearly on the record. Yours is a facilitatory role at this point of time.
A facilitatory role, yes, that's right.
Okay. Nonetheless, you have proffered this for the Minister to give consideration, I'm assuming, after doing all that work at her request.
We have reported back to the Minister on where the process of attempting to facilitate got to and the feedback that we received, and at this point she's considering whether there's any value or what opportunities or options might exist to bridge the differences if they can.
Is one of the options to make it mandatory, especially in light of the evidence that we've been receiving?
What we do know, what you know, Senator, is of course that AADA and MTAA have indicated that they don't have an issue with the principles, but they would like to see them mandated, and FCIA don't have an official position at this point. My understanding is their board has not yet signed off on considered the matter. So I don't know what FCIA's official position is on the principles. But so at this point we don't have agreement.
Okay. Thank you very much, Mr Wilson. When do you expect FCIA to give you their board's position
That you'll have to ask FCIA that question, Senator.
Okay, so are you working to a timeline to resolve this matter, or have you asked them to comply by a particular, or give you advice by a particular date?
We had a final, not a final. We had a consultation process, which we received feedback from the 3 groups, and we've reported that back to the Minister, and it's under consideration.
And when you're referring to the 3 groups, can you just name them clearly for me?
The AADA, the MTAA and FCIA.
Thank you very much. I note that you indicated in your opening remarks that you've had, and your responses to Senator Pratt, that you've had a lot of incoming points of view put to you with regard to franchising and changed business models in the car provision industry in Australia. Is that fair?
We've had a vigorous amount of input. I would have to get back to you on exactly how many submissions we received.
If you could take that on notice, that'd be great. And what I'd also really like to know is how many Australians who are really upset about haggling in the car industry you've heard from too. How active have they been in participating in these discussions? Because it sounds like there's loads of them from the evidence we just heard.
I don't believe we've had any representations from individual consumers.
So
I could be wrong, but I'll take that on notice, but my recollection is we haven't.
So in terms of Australians' concerns about what goes on with cars when they purchase them, when they drive them, when they get them serviced, they're not particularly exercised about haggling. That isn't the major concern that you'd be aware of in the industry, is it?
I truly can't comment on what drives consumers, Senator. I would also just clarify, though, that our consultations were around the changes to the franchise code schedule for automotive retailing. They were not around the different business models that were out there.
Okay, thank you for the clarification. Mr. Cully, was there anything that you wanted to add in response to the questions I've just been asking, that line of questioning?
No, nothing to add, Senator, other than to just pick up, as Mr Wilson said, that obviously we're working closely together across these range of issues.
Okay, so if I can just go back to some clarifying questions. Which minister has portfolio carriage of the franchise code and a dealership code?
Senator, the responsibility for the franchising code is overall is Minister Cash.
And that's either as a schedule of the franchising code or as a standalone?
Sorry, the Minister Cash has responsibility for the franchising code as a whole, which is a code made under regulation under the Competition and Consumer Act. The automotive principles and the automotive schedules was made separately by Minister Andrews.
Just a clarification on that. Certainly Minister Andrews led the development of the automotive schedule, but the introduction of it obviously was done in agreement with Minister Cash and
the Treasurer as well.
Given the Treasurer, given the
so what's the Treasurer's involvement?
Because it's the Competition and Consumer Act, which under the Administrative Arrangements Orders sits in the Treasury portfolio.
So if people are unhappy, they've got 3 ministers in the government to be unhappy about because there's a very shared responsibility for that. Is that correct? Or is there a hierarchy of who's responsible ultimately for this?
I believe we've outlined the responsibilities, Senator. I would say that we have had some feedback from several dealers, but by and large we haven't had broad feedback about unhappiness at all. And in fact, we've had some feedback of support for the changes.
If in the normal way that people see a problem and they want to make a complaint and they go to level 1, then they sort of escalate to level 2 and then level 3. What's the hierarchy with Minister Cash, Minister Andrews and Mr Frydenberg with regard to this issue?
Well, just on that point, Senator, if there is an issue around the negotiation of an agreement or the implementation of an agreement or the termination of an agreement, they should be going to the regulator if they have issues. if there's a issue or a concern around the overall framework and the policy settings, then that's a matter for government, and they are free to approach any minister or as a member of that government.
That, of course they can. They can approach their local members as well. But my question is really not about, you know, who's in the general space, because I think you've answered that. I'm trying to understand the hierarchy. Who gets to make the decision? Who's the ultimate person? I mean, is it Minister Cash, Minister Andrews or Minister Frydenberg?
I think this is probably the best way to answer it, Senator, and feel free to jump in, Peter, if I get it wrong. Minister Andrews would have responsibility for the automotive schedule, and so if there was a concern around the automotive schedule, Minister Andrews would be the first point of contact if that's the way you wanted to proceed. However, that is part of the franchising code, and so it would almost inevitably also involve Minister Cash, most likely in some form. To the extent it then extends into competition and consumer law, then the Treasurer would be the more appropriate point of contact.
Right. So it's a pretty complex model. You've got to have your eyes on all of those spaces. Which department's responsible for the consultation on the franchising code?
The Department of Industry, Science, Energy and Resources is responsible for that.
Not you.
No, we're in the Department of Industry, Science, Energy and Resources.
So I'm trying to understand which bit.
It sits within my division, the Small and Family Business Division in the Department of Industry.
Okay, and the dealership aspects, is that within your remit or is that someone else?
The dealership aspects in terms of the main focus of this inquiry.
Yes.
It sits across areas, which is why, as we've mentioned, we're working together. There's aspects that will sit within Mr Wilson's division, and Mr Wilson and his division have led the consultations with the stakeholders that he's already outlined. But the overall franchising code sits with my division.
Okay. So which department's responsible for legislative amendments to the franchising code dealership aspects?
The legislative amendments that were, I think as Mr Wilson has already explained, that Minister Andrews had carriage of development of those. The broader changes to the franchising code that are currently underway, Minister Cash is working on.
So is it fair to say they have to work very, very closely to deliver these legislative amendments?
That's correct, Senator.
So they're both jointly responsible?
No, I think as Mr Wilson's outlined, there's the franchising code as a whole, which covers a whole range of areas relating to franchise. There is the changes made earlier this year, which Mr Wilson outlined was the first time ever an industry-specific schedule to the code, which dealt with automotive dealerships.
Which is Minister Andrews?
Yes, that's correct.
Right, so they're working hand in glove, really? They have to be?
Yes, that's correct.
That's correct.
Just like you're both here?
Yes.
They're both there when the decisions get made?
That's correct.
Thank you.
Decisions that make changes to the franchise code have to be made ultimately by Minister Cash and the Treasurer, but Minister Andrews will input on automotive specific issues.
Thank you. Which department's responsible for unfair contract terms and the reforms proposed to them?
That's the Treasury, Senator.
Okay. Which is it the Treasurer or Minister Sukkar who's responsible for that?
I might defer to our colleagues from the Treasury.
Colleagues from the Treasury.
And the responsible minister for fair contract terms is Minister Sukkar.
Okay, and in terms of work in this area, how closely does he work with Minister Cash and Minister Andrews about these particular matters that are of such interest to this committee?
They work.
So, Senator, in relation...
In
relation to... So, the Industry Codes framework is set out in the Competition and Consumer Act. So, any changes to industry codes are typically undertaken in consultation with the responsible Treasury Minister. And in this instance, any of the changes that have just been described to the franchising code or to for the introduction of the new schedule, which goes to specifically the automotive industry issues, those changes were undertaken in consultation with Minister Sukkar.
So we've got 4 ministers involved in this space. Minister Sukkar as the Assistant Treasurer, Minister Andrews, Minister Cash, and who else?
I think it's actually three, Senator.
Minister Frydenberg, I suppose.
No, I think, Senator, the Treasury's clarified that it is
It's
Minister
Mr.
Sukkar.
Sukkar. Right, okay. Thank you. I've got another line of questions, Chair, but...
Yes, I know
Yep.
that Senator McGrath is going to take the call now.
I've got about 3
so-
questions.
Great.
Let's go, yeah.
And I've got
Thank
more
you.
once you're finished. Thank you.
Cool.
Thank you.
Thank you. Just so I fully understand, can you give me or give the committee a summary of the reforms to the franchising code that the government intends to implement?
Yes, Senator. So the government released, as Mr Wilson mentioned in his opening statement, its response to the Fairness in Franchising inquiry, and there's a range of measures coming out of that. So there are some changes to the franchising code, which include the changes to capital expenditure that were picked up, they're the part of the automotive schedule, apply more broadly. There is an increase to the maximum penalties for breaches of the code to be doubled. And a range of other measures going to issues such as providing better and clearer information up front to prospective franchisees to better understand what they are entering into and to be better informed. Looking at development of a franchise register to contain information about all of the different franchises that are operating in the country. Some changes to dispute resolution provisions. Which
Are you able to expand, considering we've heard, are you able to expand upon the other reform options for dispute resolutions?
Yes, Senator. So there's a few. One of the key ones is to expressly allow for multi-party mediation. So there are mediation processes currently under the franchising code, but they don't. If all the parties agree, there can be multi-party, but if the parties don't, it would just be between an individual franchisee and the franchisor. The proposed amendments would allow, where a mediator decides that it should be, will be most beneficial for it to be multi-party, that they can require that to happen, and the franchisor then has to engage in mediation with all of the franchisees, because in some circumstances, including in the Holden example, you obviously have a range of franchisees with the same dispute with a single franchisor. So that's one of the key changes. There is also changes to picking up in a dairy code model to allow people to agree to arbitration, to voluntary arbitration, and I know there's been a lot of evidence to this committee around arbitration. There are limits. The Commonwealth can't require mandatory arbitration.
Just on that, so we have heard from some of the answers from questions put by Senator O'Neill in relation to this voluntary binding arbitration. Can you just expand on why it isn't compulsory and how it will benefit small business franchise owners?
In terms of why it's not compulsory, it's because the type of disputes that would be resolved in relation to the franchising code would involve an exercise of judicial power. And under the Constitution, judicial power can only be exercised by a court so Chapter 3 of the Constitution says that judicial power can only be exercised by a federal court, which is specified in that chapter to be the High Court, any court created by the federal government, so that would be the Federal Court, the Federal Circuit Court, or any state court that the Commonwealth confers jurisdiction on. But beyond that, no other body can exercise the judicial power. And as I mentioned, the types of disputes under this code, because they are making a binding judgment or statement on existing rights, amounts to judicial power, and there's a long range of constitutional case law around these issues, and that's the basis on which you cannot mandate that arbitration should occur. The only way disputes can be resolved, as they can be resolved under the current scheme, is through the courts to get that exercise of judicial power.
Okay, but just in relation to the voluntary binding arbitration, how would it benefit small business franchise owners? Just how would that assist?
Well, I think consistent with some of the broader changes made to improve access to dispute resolution processes, any alternative dispute resolution process that involves the parties having to go to court would benefit small business in terms of getting a quicker, likely a quicker outcome to the dispute, and also a cheaper one. And that's why the code has been evolving. So in 2015, there was a creation of the franchising mediation advisor and a requirement that mediation must occur. And so that's the process where if there's a dispute and the parties cannot agree on a mediator, the Office of the Franchising Mediation Advisor will direct them to an advisor that they have, a mediation advisor that they have to use. So it's and that was the first steps. The steps that the government has now announced in response to the Fairness in Franchising report go further than that by, as I say, allowing for multi-party mediation, expressly allowing for voluntary arbitration, and all of which is consistent with an approach that if the parties can have the dispute resolved in a more expedited manner and avoid the legal system where possible, that'll be a beneficial outcome for small business.
Okay. Thank you. Thank you, Chair.
Ask very quickly in the context of the different roles of the Department of Industry and small business in terms of the delineation between Minister Cash and Minister Andrews. Noting there's already something of a separation, and other countries have quite separate codes for automotive dealerships versus other kinds of franchises. What's the rationale for the current separation, keeping car dealerships within the existing franchise code, but with some alterations through the Department of Industry and Minister Andrews?
Senator, I'll commence, and if I miss anything out, I'm sure Mr. Wilson will add to my answer. So first of all, automotive dealerships were already covered by the franchising code.
Yes, I know that.
Yeah, and it's an express definition in the franchising code that effectively deems automotive dealerships to be franchises. So that's, I think, an argument for why it remains in the franchising code. There are some particular circumstances in relation to car dealerships that make them different to other franchises. I mean, franchising is obviously an incredibly broad sector. There's 1,200 different franchise arrangements in the country, 90,000 franchisee units. Across a very, very diverse range of different businesses, and car dealerships have some very unique characteristics that are different to that, including their size and scale, and some of the issues around capital expenditure and so on. And so I think the argument was that there are there's a lot of things with car dealerships that are consistent with broader franchises, so they would be dealt with by the franchising code. There are some unique aspects, and that's why there's the sector-specific schedule.
You would in effect have two bills which were, 98% identical with a small difference, and then whenever there were amendments to the franchise code, you would have to update the other code, etc. The risks of separation and confusion were considered to outweigh the sort of marginal benefits that a separate code would have as opposed to a schedule. In practice, there's no real difference. It's just an optical issue.
Thank you for clarifying that. Senator O'Neill?
Thank you. Could I ask the dairy code, by having a separate code, what does it do in terms of options for the sector? What would it provide?
Senator, the dairy code is, in my understanding, and I'll confess up front, it's a limited understanding, but it is applying to the dairy sector as a whole, which has its own kind of commercial and other arrangements and structures, whereas the franchise code applies to franchises, of which automotive dealerships are a subclass.
We're seeing a change, though, to the business model that looks quite different from a franchising model.
The dairy code, as I understand it, is not a franchise code. It's a broader industry code, so that's why it's different.
I guess the franchising model in cars is now being disrupted. It's not exactly a franchise model anymore once these changes that have been implemented come through.
Well, I think, Senator, we have not yet seen any of the proposed details of the agreements of what the manufacturers are imposing. And obviously the ACCC, as the regulator, would be best placed to provide advice on that. But a lot of it will come down to what the actual arrangements are. If it has all of the hallmarks of a franchise, but is simply called an agency model, that doesn't take it outside the franchising code. No. If it still retains those characteristics of a vehicle dealership, and the other characteristics of a franchise around the level of control from the head of
the franchisor,
and all of those elements, then it would still be covered by the franchising code.
My understanding is that I think it's either Honda or Mercedes have certainly said that their understanding is that it will still be under the franchise code, their agency model. There's no sort of a priori reason why it wouldn't be.
Okay. Just following up on Senator McGrath's questions around impediments that you've articulated there, is it correct that binding arbitration could be regulated in an industry code if participants opt into that industry code?
If participants opt into the code, then they effectively consent to arbitration. So it still retains that voluntary element because they have to opt into the code. But so
let's talk about this as a practical solution, because the argument is constantly made by the FCIA and on the public record that it's impossible to have binding arbitration, and there's a massive constitutional problem with it. But the reality is, what you just said is, if you wanted to do business in Australia and there was an industry code, if Mercedes-Benz, for example, wanted to be a part of that code and signed into it, then they could be subject through that vehicle to binding arbitration.
Yes, but it would be voluntary binding arbitration because they have chosen to be covered by that code.
Right. So it's not voluntary in terms of the way sort of the general public view might, you can join it or you cannot join it. It's voluntary in that you have made a choice to join the industry code, and by doing so, you therefore agree to mandatory arbitration.
That's right, Senator, and that is in effect the same principle that the changes in the fairness to the franchise code, the voluntary binding arbitration process is in effect the same thing. Parties to the agreement would agree to binding arbitration up front in their agreement. That would be the same principle as adjoining an industry code which requires you to do that.
So when we're talking about voluntary and mandatory, there can be a lot of confusion in this space. The main concern I have is for 56,000 Australians who work in this industry, the communities that they provide business in, the service that they provide to travellers around this huge, wonderful country, the community support that they provide, and how significant they are in regional economies across this country. Given that, all of that, and very mindful of risks to that structure, we've heard from the MTAA, we've heard from the AADA, that they want the principles that we talked about to be mandatory, and they want whatever vehicle necessary to be provided so that, in essence, there is mandatory arbitration if a relationship between a large overseas corporate provider of cars and a local small business or medium business or large business finds themselves in dispute. Is it within the capacity of the government to create structures to enable the AADA and the MTAA to have the protection they seek?
Senator, my understanding of what they seek is that arbitration would occur in all circumstances, regardless of whether the vehicle manufacturer wanted to participate or not. If there was a model as the existing, what was being proposed with the franchising code, as I've outlined, that would have to be that the manufacturer agrees to be bound by binding arbitration. Similarly, in the case you identified of any other sort of potential voluntary industry code that people sign up to and it's then binding arbitration, it is still in the choice of the manufacturer then about whether or not they sign up. So I appreciate the confusion around some of the terminology, but there is not an outcome that those parties seek, which is to ensure that in every circumstance there must be arbitration, regardless of whether or not manufacturers want to participate. That is not possible under the franchising code.
I would also just note, Senator...
Can I just ask, before we come to that, I'm happy to take that.
Yep.
What needs to change to make it possible, Mr Cully?
Probably a constitutional referendum, Senator. It is a constitutional issue that is the issue there, as I say.
There is no vehicle. There is no vehicle to give the assurance to this big sector that employs 56,000 people.
It is a constitutional issue, Senator. It's a constitutional limitation on who can exercise judicial power. Is the issue here that prevents mandatory arbitration.
And you have no vehicle at all that can be constructed to provide the necessary place in which arbitration could occur with the OEMs voluntarily coming in to accept that.
If they come in to voluntarily accept arbitration, there is...
As a structural volunteer, rather than an incident by incident, I will negotiate on this matter. I'm talking about a structural establishment.
Any mechanism would still require them to volunteer, whether it's to sign up to some sort of more broad industry-wide code or whether to agree in their individual agreements that they would be bound by voluntary arbitration. But in both cases, they would have to opt in. There is nothing that can be done to compel them to participate.
But if the bulk of the sector did opt in, that would create the context in which it would be a likely inducement to others to opt in.
Well, it depends on, if we're talking about the franchising code, Senator, we wouldn't be talking about, you wouldn't want an opt-in model in any event because that would allow parties to just completely sidestep the franchising code. If it had to all be that franchisors simply opted in. And then otherwise, it's a hypothetical question, but I can't think of any sort of code or other thing that would be sufficient for, that they would need to opt in for to effectively require them to, or they would have no other choice.
And what about the grocery code, food and grocery?
Again, that's a voluntary code.
Senator O'Neill, can I just ask a complementary question?
Yes.
If we are trying to negotiate outcomes for Australian business in the context of global multinationals or foreign companies, are we relying only on outcomes in the courts for the laws as they stand? Do we need to make new laws, and does arbitration exist only if we create a form where it can come before the courts? Or are there other mechanisms internationally, that we're able to use to negotiate with foreign multinationals or foreign companies?
Senator, I don't think there is, in terms of if what we're looking at here and the situations where arbitration is being looked at is in relation to disputes between either individual franchisees or groups of franchisees with a franchisor who may ultimately have a be controlled by an overseas entity, it would still relate to a dispute within Australia that would need to be resolved within the Australian system. And as I've as I said, because it involves an exercise judicial power, it would need to be done by a court, unless the parties agree to some other process, which could include arbitration.
So,
Well,
in essence,
or unless we create a legal mechanism where arbitration is the equivalent of a court as we do in an industrial relations context.
Well, in an industrial relations context, Senator, it still is where its judicial power is exercised by a court. So it was actually one of the leading cases around what constitutes an exercise of judicial authority, and setting out some of these principles was the Boilermakers case, where there was an attempt to give the Commission a greater power to, and that was found to be an exercise of judicial authority. And because the Commission is not a Chapter 3 court, they couldn't do it.
Yeah. Can I ask in that context how, if that means arbitration, smaller players who are more vulnerable in that power dynamic can, it ultimately always means that the bigger player is able to walk away, which means even when arbitration is taking place, because there's nothing binding it, it still leaves vulnerable the power dynamic, even if people have fought, even if overseas companies do participate in arbitration.
Senator,
is there a logical way through this?
Well, Senator, that would very much depend on how the arbitration arose. So if, for instance, as is proposed with the changes to the franchising code, to expressly allow parties to agree to arbitration, have that in their agreements. If a franchisor was to have in its agreements that it would participate in arbitration to resolve disputes, it could not walk away because it would be breaching that part of the franchise agreement, that part of the contract. Okay. Similarly, if it was another separate sort of process by which they've agreed, it would be how they've agreed to be bound by that arbitration. But generally, if a party has agreed to be bound by an outcome and got into that process, it can't then walk away from the arbitral process.
So there's.
Can we legislate for contract terms within franchise agreements that they must include arbitration, or do we end up in the same constitutional problem?
Unfortunately, we end up with the same constitutional problem, Senator.
I feel that there's a capacity for the government to find a way that that they can say to these big multinationals, like they're having to deal with, like the PM's out there talking about how he's going to, crack the whip and sort out the media code to make sure that exploitation of Australian businesses is not going to happen. If the PM's out there doing that, I guess really the question for this whole inquiry and for the ministers, the relevant ministers, is, are you going to sort out this issue so that businesses can be protected, and say to these big companies, if you want to do business in Australia, you just have to agree to these principles. I guess I feel that what needs to change really is an intent from the government to ensure a level playing field for, Australian businesses against huge overseas entities. How can we have a Prime Minister who's out there articulating protection in the public interest, not just as an arbitrary concept, in the public interest around media, when this big car industry with 56,000 employees can't be looked after?
So Senator, I guess I would possibly challenge some of the assumptions in the statements. One of the observations that we have as the department is that there is an assessment of the current frameworks being applied to basically past events, which is the Holden contracts and the Holden disputes. Those contracts were signed in a different time under a different regime. Those contracts probably would not be signed, or the way that it occurred could not occur under the new franchise code regime if those agreements was developed now. There has to be, and this relates to my point that the framework has changed. Considerable protections have been brought in. They haven't yet been tested and I think even fully understood. The unfair contract term changes will bring unfair contract term regulations and apply them to quite a substantial, if not all, the dealers, whereas they might not have been available before.
Can I go to some questions around that?
I think that will change the equation considerably. The ability for them to collectively bargain is also a new and very significant change that is yet to work through. At the end of the day, there are commercial negotiations between parties, and government will not get involved in those negotiations.
I know, and part of the problem is right now there are basically collective groups of dealers from within each of the franchise groups that are coming collectively to this committee and saying, these are our problems. We need the government to intervene and fix. And they won't do it publicly. They're not here giving public evidence because the power differential, as it stands in Australia today, is still so tilted towards the overseas companies against even collective groups of some of, very experienced business people across a range of car manufacturing distribution networks. They're collectively bargaining, but they're too frightened to do it in public.
Again, as I said in our opening statement, if there is examples of where they believe they're being coerced or pressured or dealt with unfairly, they need to go to the regulator. And my understanding is the regulator hasn't seen a lot of these complaints, and that could be a question that you could address to them later. We would very much encourage that. If people think they're being treated unfairly, they should go and
How public is that process?
That'll be you'll need to ask the ACCC exactly how public that is.
Because I fear that it could be.
If I could also just go back on a previous question, when you talked about if enough of the industry opted in voluntarily to the binding mandatory, the binding arbitration process, etc.
Yep.
In essence, that's almost what the guiding principles were being developed in to do, which was to say, if you follow these and you do and you undertake this and you negotiate these points in developing your agreements, then and companies agree to abide by those principles, which was the intent, and buy into it. In effect, that's what you're generating. You're generating a change in behaviour.
These 6 principles that are the critical part, then, in your view, that need to be mandatory.
No, that's not what I said, Senator.
Okay, can you clarify for me?
We believe that the adoption of or the adoption by industry of principles that would guide the behaviours as outlined in the principles would go a long way to potentially reducing the grounds for dispute should the contracts be terminated early by getting these issues addressed upfront in new agreements. And it is really just there to guide parties in the development of agreements consistent with their obligations.
But as you said in your opening evidence, that there is no agreement about these yet. So that option isn't actually on the table.
As a department, we think that's regrettable. We think it's a missed opportunity if industry don't come together to develop this shared vision, which we think would benefit the industry.
The FCAI don't support it at all, and the AADA want it to be stronger.
And they're entitled to their views, Senator.
If I could just go to the 2018-19 MyEFO, on pages 200 and 201, it promised developing an automotive industry code of conduct to support appropriate commercial dealing and competition in the new car retail supply chain for the benefit of both small business and consumers. Where is that code?
Senator, I'm not, without having the document in front of me, I'm not sure what it may be referring to.
So I can read it again. I'll quote to you. Yep. It's from MyEFO. It's on pages 200 and 201. Perhaps the Secretariat might be able to help us out with this. The MyEFO pages 200 and 201, 2018-19. And the government promised, and I quote, developing an automotive industry code of conduct to support appropriate commercial dealing and competition in the new car retail supply chain for the benefit of both small business and consumers. Where is that code?
Senator, I think, I'm not sure whether our Treasury colleagues may be able to assist. That may be some of the work that Mr Mr Wilson referred to earlier around things like access to repair information and so on, it's certainly not something that's sat within my division's responsibilities.
Okay, but it does say competition and it does say small business, but that's not you in this instance.
Not in this particular instance, no, Senator.
So there's a
Senator,
gap there.
I might just jump in.
Yep, Ms Lynch.
Sorry, Senator. To clarify, my understanding is that the auto code that's referred to in that MyEFO document was essentially overtaken by events, was overtaken by the new regulation that's attached to the franchising code. There was some discussion earlier on that if it was designed as a standalone auto industry code, that it could potentially also incorporate work that was being done on the mandatory information sharing scheme for motor vehicle service and repair information. Those items were separated out, and the information sharing scheme for service and repair information is currently being progressed in the Treasury portfolio. It's being designed as primary legislation.
But the parts that deal with competition and small business is not being dealt with because it was, as you say, overtaken by events. So that code is not the voluntary one, or it is the voluntary one proposed by Minister Andrews?
My understanding is that it was essentially replaced by the new regulation attached to the franchising code.
The voluntary one?
No,
that's right.
The automotive specific schedule to the franchising code.
I think I apologise, Senator, it does predate me and my involvement in this area, but if I understand my colleague from Treasury, that commitment of the government was subsequently overtaken or turned into the automotive schedule that's attached to the franchise code. And it was other aspects were also progressed through different parts of work.
Okay, so this is kind of where it cracked and started to spread across the different sectors that we were discussing earlier on. I think it's fair to say that the government presented it at the time effectively as a mandatory standalone industry code that was sought by the dealers, and I believe they had some support for it. Well, why didn't the government proceed with the standalone dealership code as they indicated they would?
It comes back to our previous answer, Senator. The industry code has transformed into the schedule that's been attached to the franchise code, the automotive schedule. The decision to proceed with a schedule rather than a standalone code was taken for reasons of efficiency and simplicity. And also just
but it doesn't meet the promise to the sector, and it hasn't resolved the problems that we've been hearing about in these 2 days of hearings.
Well, our conjecture, our point, Senator, is that it has only come in. It has yet to actually work its way through the industry in terms of new agreements, including the unfair contract terms and the important changes to the franchise code. We simply can't support a statement that it is ineffective because it hasn't yet had time to be tested.
Okay, so we're in the sort of trust me phase of the government's implementation of what they promised.
We think it provides a considerable change in the balance of the power relationship. It gives dealers a lot more.
We hope it does, but we're not proven that it does.
Well, that will take some time.
And in that period of time, general monitors have left. They've checked out of the country. How will unfair contract terms reforms? Does the franchise code protect dealerships from unfair contract terms?
Unfair contract terms are dealt with separately, Senator. They form part of the broad framework, but they're not part of the franchising code itself.
But
right.
they still apply, so
they still apply, yes.
Protection.
Yeah.
Okay. You can understand how this can all get a bit confusing because there's so many bits of it in so many places, which is why I think the allure of a standalone was something the government actually figured out they should promise, because everybody's saying, give us our own code so it's clear what we've got and what we haven't got, and give us the opportunity to get the protections we need. Now we've got this dissolved, morphed, different bits in different departments. It's quite, by design you say more efficient, but perhaps not for the people who need it.
Yeah. So I can assure you, Senator, that behind the scenes we are working very closely together, and it is efficiently taken forward. I do, having talked to a number of the industry participants now, we are getting feedback that they would appreciate better communication of the overall frameworks and protections rather than the individual bits, because I think there is quite a legitimate point that the dealers, who are not lawyers and not experts in government regulation, probably aren't seeing the overall framework at this point.
Because it's very
and we could do a better job
dissected.
at communicating that, I think.
Senator, just to add to that point in relation to unfair contract terms. So unfair contract terms are dealt with in the Competition and Consumer Act. As I mentioned, the Franchising Code is made under that Act. But it's also important to note that the unfair contract terms, they obviously will be relevant to franchisees, but they'll also be relevant to small businesses across the economy and not just those in franchise arrangements.
Okay, so the crossover happens there. How will the unfair contract terms reforms be paralleled in the Franchising Code? Will they be?
No, Senator, because the unfair contract changes will be made to the primary act, to the Competition and Consumer Act. They'll have broad application. They will apply across all sectors, and so there's
And
no need to
franchising
have-
will just sort of be an extra bit of where they apply.
that they'll apply to franchising arrangements as well.
Okay.
Yeah.
So not all dealers are going to be protected from these unfair contract term reforms, though. How will the department or the departments ensure dealers in their schedule of the Franchising Code are protected?
I'm sorry, Senator, I'm not sure which dealers
We
you
don't.
mean.
I can't say, Senator, that I can agree to the statement that not all dealers will be covered. I don't have that information. My understanding from talking to some of the industry folk is that they believe it should cover pretty much all, but that's still being worked through.
So pretty much all. So is this the matter of the 100 employees and the 10 million, or is it related to turnover?
So, Senator, I might just jump in and provide a quick summary of
Thank you, Ms Lynch. Yep.
Thank you. So the changes that have been agreed for reform to unfair contract terms include changing the eligibility threshold for the protections. So unfair contract term protections apply, as Mr Cully said, across the economy, irrespective of whether the participants are franchisees or not. They provide protection to both consumers and small businesses.
Okay, so my question goes to, will all dealers be covered? Can you give me that assurance that every single dealer is covered?
I can't guarantee that every dealer will, Senator, but the changes go from increasing, the scope has vastly increased the number of businesses that will be captured here.
Okay, so vastly increased is not all dealers. And I guess this again goes to the need for a standalone code and specific confirmation in the sector of their protections. So this generalisability across small business is not actually going to cover all of the businesses that are operating as motor dealers in Australia.
Well, Senator, I think...
Senator, we're not aware of any dealerships that wouldn't fit within the new definition because it's an either or. So it is, you can have fewer than 100 employees or you can have a turnover less than $10 million annually.
And what about ones that sit outside that?
Well, Senator, they would not be small businesses on any of the definitions that are currently used. So the definitions that we use of small business are either under fewer than 20 employees, and so this goes up to 100, or a turnover of less than $10 million.
Okay, so a turnover of 10, like, there are companies that have put on the books, on the record, how many people they employ, and $10 million would be absolutely nothing in terms of the amount of money that's going to be turning over in a car yard. So what have you done to reassure the Minister that this is going to provide the protections that are being promised to the motor dealers?
The feedback I have from the dealers, Senator, the ones I've talked to, is that they would expect that threshold and the way it's applied to the new car operations would cover the vast majority of dealers, except potentially the large ones, but even then they couldn't be sure.
Right, so we've got
And
no clarity around that.
as of today, I haven't had any feedback from the dealer associations that they're concerned about it. That's
So
not to
this is
say there
being-
might not be, but I haven't
Yeah.
had any feedback.
sorry to rush you, I'm very mindful of time now, and
Yeah.
I've just got a few more questions, and I thank you for your answers. And if there's anything more you need to put on the record, I'd love them on answers on notice, more fulsome if possible. But at this stage, to be clear, there is no guarantee that what is being proffered as a fix to the problem, the unfair contract terms, will actually apply to every car dealer. There is no guarantee that that's the case. It's not known if it will be the case.
We don't have any evidence that it won't, Senator. And it would
But you don't have any evidence that it will.
It will absolutely apply to the smaller, medium-sized businesses, which we understand is where the power imbalance is of biggest concern. The very large dealers, as yet, I still don't have feedback whether it will apply or not.
When does Treasury expect consultation legislation to be available for the changes to the unfair contract terms?
Yes. Senator, we're expecting an exposure draft of legislation to implement the changes will be released for public comment next year.
When next year?
But we can't be sort of more specific because the exact timing will depend on sort of legislative priorities and drafting resources. But at this stage, it's certainly our expectation that it will be released for consultation next year.
So unfair contract terms, we'll see how much of a priority they are for the government if it comes in February, if it comes in December. You can't give me any indication of the likelihood.
Senator, sorry, the prioritisation of drafting is a matter for government.
So there is no drafting underway at the moment? Or is there drafting underway at the moment?
So we've commenced now that the Consumer Affairs Forum has agreed the reforms. We've certainly commenced work on preparing for drafting once we actually have access to drafting resources. But the timing of the release of exposure draft legislation, as I said, we can't be more.
So it's in pretty early days. What threshold is the government going to consult on for small business eligibility for unfair contract terms? Is it the 110 million?
Yes, Senator, that's the decision that has been taken now by all of the Consumer Affairs ministers.
What interdepartmental work has been done to ensure that dealerships, many of which might have high turnover but slim margins, and power imbalances akin to small business dealing with large businesses, will be eligible for unfair contract term protection?
We are engaged in the process led by Treasury around the development of the unfair contract terms reforms. We're engaged in that process and we're talking to the industry.
Okay. When do you think you'll have the answers to those questions?
I can't say, Senator.
Is it the government's intention to ensure all dealers are protected by the unfair contract terms? Do you know if that's what they want to do?
I'll have to defer to my colleagues from Treasury on that one.
Whether it's through the franchise code, dealership schedule or unfair contract term reforms?
So, Senator, I'll just reiterate that the unfair contract term reforms are economy-wide. So the government's intention in relation to the unfair contract term reforms is for them to apply to all consumers and to all small businesses as defined under that definition. So and we anticipate that will include the vast majority, if not all, of motor vehicle dealers.
Okay, but it's not going to be in a dealership schedule. Just with regard to the draft principles, to be clear, the draft principles did not come from you. You simply facilitated their construction following consultation with the AADA, the MTAA and the FCAI. Is that correct?
That's correct, and we had input from those associations. The principles, I would say, largely reflect those from the dealer's side of the equation.
Okay, and in terms of voluntary, mandatory, were there discussions about that?
There were. We did, in the process, to facilitate the development of the principles, keep the two issues separate until towards the end, and at the end there were clear views expressed, which you've heard from all parties. I would just also note, Senator, and I wasn't able to say it before.
So can I just reflect on that?
Yeah.
There were clear views from all parties.
Yep.
So the clear views of the MTAA and the AADA are what? They want voluntary or they want mandatory?
As I said before, Senator, the AADA and the MTAA both supported mandatory application of the principles. The FCIA informally, because they don't have an official board position, indicated that they did not see the need for mandatory principles.
Right. So to be clear, when we look at these draft principles and they've been articulated as voluntary, you've come down on the side of the FCAI, which represents companies that exist overseas, as opposed to supporting the wishes of small businesses in Australia, small, medium and large businesses in Australia, that want a mandatory set of principles. Why did the FCAI succeed when they don't represent Australian businesses?
So I don't agree with that statement. The government has not come down on any side, Senator. As I said, we took the principles as far as we could, working with the three groups, and we've reported the views back to the Minister. The Minister initiated this process at the request of the dealers to develop an industry-led set of principles, and we have gone as far as we can at this point. Given the two views, the government has not got a view, as far as I'm aware, on the application of those principles beyond that.
So, in the Australian on the 18th of September, Minister Andrews stated that the intention of the government is for the development of these principles to be led by industry. Does the department acknowledge that the FCAI, as a peak body, does not represent any wholly owned Australian company, but rather overseas companies selling products in Australia?
I do not know. I don't know who the FCIA represents. I can't comment on that statement.
But Mr Wilson, you're the one who's doing the work.
I don't have their membership list in front of me. I can't verify whether they do or don't have Australian. I would note that those multinational companies, though, are registered businesses in Australia. And under our free trade and other obligations, we don't discriminate generally in policy between overseas and Australian businesses.
So let's be clear, Mercedes-Benz have 300 people working for them in Australia directly, but the dealers have 3,000 people working for them and 230 apprentices. Mm-hmm. There's a difference there, Mr Wilson. I know which side I'd pick. I'd be picking the Australian businesses that are in our community, the Australian people that I live with. I wouldn't be picking a multinational over there.
Again, Senator, I don't agree with the statement that we have picked any side.
If the government chooses not to make these mandatory, they'll be picking a side though, won't they?
What the government chooses to do is a matter for the government. I can't comment on that, Senator.
Well, I would hope the government would choose 56,000 jobs for Australians over a much smaller number of jobs for overseas companies represented in Australia when the time comes. Does the department acknowledge that there are concerns around Honda, how Honda, Mercedes-Benz and General Motors conducted their business operations with local partners?
We acknowledge the reality that there are some concerns. We also acknowledge the reality that the majority of the dealers in those frameworks have signed on to agreements and have agreed to compensation arrangements, but there are a smaller number who are not happy. That's right.
And can I put on the record that even those who have signed on should not be considered as companies that were happy to sign on? Many of them have indicated that they were coerced into doing so. They felt pressured. They didn't have sufficient support from the government to stand up. They weren't in a position to exercise power against multinational companies. Even though they've signed up, it doesn't mean that they agreed with what they had to sign up to. They felt powerless. Many of them have articulated that. So I'm very concerned that basically the fact that they actually gave in under pressure because of the financial weight that they feel resting on their shoulder doesn't mean that they agreed with the way they were treated. Yep, thank you, Chair.
Senator O'Neill, I'm going to have to draw you to a close so we can go to our next witnesses once they've answered those questions. Thank you.
Thank you, Chair. The last question, if I could, does the department acknowledge that every Australian car dealer wants the principles that you've drafted for the Minister to give consideration to be mandatory and not voluntary?
We acknowledge that the AADA and the MTAA and a number of the dealer sub-associations have indicated that, but I certainly can't say that every dealer in Australia wants that.
But they are their representative bodies, Mr Wilson.
All I know is that the AADA and the MTAA and some of the dealer associations like the Holland Dealer Council have indicated that they strongly support mandatory application of the principles.
Thank you. Thank you very much. Thank you, Chair.